Hello everyone. So today in this session we are going to start with various rules of interpretation. Various rules of interpretation. Interpretation of statutes chapter la there are three very important concepts from the exam's point of view. Number one, internal aid of interpretation, external aid of interpretation, and various types of interpretation. Okay, various types of interpretation there are totally 9 different kinds. In that 9 different kinds, we are going to discuss one by one in the today's session, starting with the concept of literal construction, reasonable construction, harmonious construction, beneficial construction, exceptional construction, and the rule of ejus dem generis. These are all the primary rules. There are also secondary rules in that. Secondary rules will be noscitur e socis, contemporanea expositio, and expresso unius est exclusio alterus. The last one, what I said now, is not there in your syllabus, but just I will give a summary of what is the meaning of that. Technically, there are 9 different kinds of rules of interpretation. Okay, this question will be coming for around 5 marks in exam. Okay, from internal, external, one question will come. From the various rules of interpretation, one question will come. Technically, overall together, you can find 5 marks question in exam, counting for 10 marks in this chapter, interpretation of statutes. Okay. So before going into that, let us first begin understanding the concept of interpretation rules. First one is the rule of literal construction. Rule of literal construction. Let's see. See here. Let's begin. See here. Primary rules. First primary rule is rule of literal construction. Rule of literal construction. I will first tell you one point. After that, we will be going into the analysis. Point number 1. Rule of literal construction, what it wanted to tell. Let me first explain. Once you understand that, we will see the study material. Okay. Whatever is relevant from the exam point of view, we will write in a short notes. Okay, like that for all the 6 primary rules, 3 secondary rules or 2 secondary rules, we will write a short notes. In examination, if a question comes, we should be in a position to gap that particular 5 marks given in the exam. Okay, with that intent, let us start with this concept, rule of literal construction. Okay, point number 1. First, what is the first rule of interpretation? Literal construction. What it wanted to tell, let me explain. When the language used in the act is plain, okay, when the language used in the act is plain and is unambiguous, ambiguous means vague, unclear, okay, unambiguous means everything is clear. When the language used in the act is, okay, unambiguous and it is clear and it is plain, that means there is no there is no chance of giving 2 meanings for the words used. Then always courts should apply the rule of literal construction, where understand the phrases or words in the way in which legislature wanted to convey. Okay, I repeat. When the language used in the act, okay, can have a possibility of only one and only way of construction, then courts will not go into interpreting them in a different way. When the language is plain, go with the plain language of the act. Don't unnecessarily create an issue with the sections. Okay. So the point is, when the language used in the section is possible of one construction only, okay, courts will not get any right to go for a different interpretation of the terms. Number 1. Okay. So then how to read? Give its grammatical meaning and read. Normal plain English la read that. Whatever meaning comes, apply that directly. Example I will give you, because institute does not give any great example for that. Therefore, I will give you an example. After that institute example also we will see. Okay. Listen carefully. Point number 1. When a section says like this, see here. notice of general meeting should be notice of general meeting should be given to every member. Okay, every member. Next one, debenture trustee, to the debenture trustee. Number 3, other persons authorized, other persons authorized. This is the language used within the section. Okay, so the main point is notice of a general meeting should be given to every member, debenture trustee, any other person authorized to attend the general meeting. This is how law has used. Now you read it. Notice of a general meeting should be given to every member. What do you mean by every? Every means even past members who are not there in the company today, that is also a member. Like this, you should not unnecessarily create a doubt. When the language of the provisions is very clear, when the language of the statute is very clear, so that only one interpretation is possible, unnecessarily court should not go extraneous to what is there in the section and go for overaction interpretation. Means what? Language is plain. Notice of a general meeting must be given to every member. Means what? Every existing member. That's the meaning. That's all. Every member means every member of another company also. Na? Every member of the company means which company? Our company, other company. What is that interpretation? Are you understanding or not? Every member of a company. Which company? Our company or other company? Every member means which every? Present member or past member? Like this, unnecessarily we should not go into interpretation when there is only one chance of interpreting the words. Okay? You read the section. Plainly you read with a grammatical meaning. Okay? It gave one grammatical meaning. That's all. Give that meaning and read the section. When grammatical meaning is giving a wrong, when the grammatical interpretation gave you a wrong meaning, or there are multiple interpretations possible, then you need to go for other interpretation concepts. So, rule of literal construction says like this. Sir, technically listen. Study material of what institute has done is same point they repeated 6 times in the material. But all the 6 times you need not repeat the same in exam. Yeah. So 4 to 5 important points we need to write in exam. I will make you to write those in a summary today. Before going into that, first and primary rule of construction. Okay, first and primary rule of construction is that the intention of legislature must be found in the words used by the legislature itself. Means don't go beyond the bare act. Legislature means the act. From the law you read, from that what meaning will come, apply the same meaning. Okay, so the first rule is lawmaker intention. What is the intention of the law? Read the law and understand his intention. If words of statute are capable of one construction only, construction or interpretation, anything, okay, then it would not be open to the courts to adopt any hypothetical construction. Hypothetical means beyond literal. Literal construction means one name lone clear. Literally read the section and understand in the grammatical way. Okay, when there is only one meaning capable, unnecessarily don't go for hypothetical construction. Are you understanding the point or not? Point number 2. Next, again same thing they will repeat in the study material. It is the cardinal rule. Means it's the most important rule that statute must be construed. Construed means understood. Literally. Literally means no interpretation, no other interpretation. Read in the same way. And grammatically giving the words their ordinary and natural meaning. Ordinary and natural. Give them ordinary meaning. Every member means what? Every existing member. Okay. Therefore, the language used in the statute must be construed in a grammatical sense. Again, same point repeated. Okay. The correct course is to take, okay, the words themselves and arrive is possible at their meaning without reference to the cases. Means what? Whenever a particular word or a phrase is used, interpret them in the same way. Don't go for the case laws and search for the case and judgments. Are you understanding? Read in the plain way. Again repeated the same concept. If the phraseology of a statute is clear and unambiguous and capable of one and only one interpretation, then it would not be correct to extrapolate, means going beyond these words out of their natural and ordinary sense. Again repeat the same point. When the language of the statute is plain and unambiguous, it is not open to the courts to adopt any other hypothetical. Same lines they are repeating. Here also same. Thus, it is a primary duty of the court to interpret the words in legislation according to grammatical meaning. Okay, next. Normally, where the words of statute are clear and unambiguous, it should be construed in ordinary and natural sense. Same thing is repeated. So, in exam question comes, all this nonsense I can't write repeatedly, same song. Okay, there must be 5 important points you need to write for 5 marks. Okay, write on the notes. Keep the heading, rule of literal construction. Keep the heading. Rule of literal construction. This is the example. This is the example. This example also I will tell you. In a simple language we can write it. Rule of literal construction. Keep the heading. Point 1. Point 1. Point 1. This is the first and primary rule of construction. Write down. This is the first and primary rule of construction. Fastly. This is the first and primary rule of construction. Point 1. Point 2. This rule says that intention of law must be understood from law itself. That means read the law and understand the meaning. Don't go beyond the law and try to do certain new things. Every member means what? There is a definition, section 2 clause 55. Go in the law, read it, understand the meaning, that's all. Why you are unnecessarily, member means which member, our company, other company, past member, present member, why all these? Member, there is a definition under Companies Act. So whenever words are used, okay, give the meaning what is used in the law itself. That's the meaning of rule of literal construction. Okay, point number 3. If words of a statute means bare act, words of a statute are capable of, if the words of the statute are capable of one and only one interpretation, one and only one interpretation, it is not allowed to the court. It is not allowed to the court. It is not allowed to the court to adopt any hypothetical construction. Underline that, hypothetical construction. To adopt any hypothetical construction. Hypothetical construction. Full stop. Point number 4. Point number 4. That means a statute must be construed literally. Underline this word. Construed literally and grammatically. Don't do overaction. That's the meaning. Grammatically read it and complete. Why you are unnecessarily making an issue with the language? Construed literally and grammatically, giving natural and ordinary meaning. Giving natural and ordinary meaning. Okay. Next point. Point number 4 or 5? 4. I think 5. 5. Point number 5. Okay. Next. If the language of the law is plain, comma, clear, comma, clear, and unambiguous. All these three words underline. Plain, clear, and unambiguous. It would not be correct. It would not be correct. It would not be correct to extrapolate. Extrapolate means going beyond. To extrapolate these words out of their natural and ordinary meaning. Out of their natural and ordinary meaning. Natural and ordinary meaning. Natural and ordinary meaning. 5 points. Below write down. Example. Example. The word every member used in section 101 refers to below write down. Refers to below write down. Company's member and present member only. Present member only. And no other extrapolation to be made. No other extrapolation to be made. In the study material, that's why they used a beautiful English word, sugar coated pill, extrapolate. If you ask me in a crude English, if I have to tell, don't do overaction. That's what they mean. When the language is plain and clear, don't do overaction. Don't show your full talent in reading the law now. Because it's only giving only one meaning. Why you are unnecessarily doing overaction? Is the meaning of this particular concept. Okay? Next, point number 6. Example will again continue. This point is important. Mark this star. Star mark. Why? I will tell you. First listen, after that we will write. When a particular word, literally you are reading. Okay? You are reading literally. But there is a word which is possible of giving two types of interpretations. Okay? Possible of giving two types of interpretation. That means grammatically there are two meanings for that. Okay? You said that read in a literal, natural, ordinary, grammatical way. I am reading in that way. But I am getting two types of meaning. Which gives, that means I can give two meanings for a word. One is narrow interpretation, one is broad interpretation. One is narrow interpretation and the one is broad interpretation. Which one to apply? That depends on the nature of the section. That depends on nature of the section. I will give you two examples. Instead of give one example, I will give you two examples. See here. Number 1. They said like this. As per section 102, explanatory statement has to be given. Which statement? Explanatory statement. I am not going to explain about explanatory statement. Elaborate discussions we made in the class. Section number 102 says explanatory statement is mandatory. Okay? In that what should be there? They should contain nature of concern or interest of director, manager, KMP, relative. Okay? Nature of concern or interest in any contract or arrangement. Okay? With the director, manager, KMP or their relatives. What does it mean? No director, no KMP, no manager, none of their relatives should take bad advantage of company's money. Means what? I will explain. Company entering into contract with the brother of director. Okay? Normally, company purchases at 100 rupees per kg. Since he is a brother of director, they are ready to purchase at 110 rupees per kg. That means he is getting an advantage of extra 10 rupees or not? Yes. Let the shareholders know about this. Don't do it in a secret. Don't do it in a secret. Okay. Now, the point is, what I have to disclose? Nature of concern. Nature of concern. Now the question. So, nature of concern, he said. What I need to disclose in the nature of concern? Question will arise or not? What I have to explain the nature of my concern? Therefore, nature of concern means I can just say, he is my brother, he is my relative. This is one way. He is my brother, with him company is entering into contract. This is one way of understanding the nature. What is the nature? He is my brother. Number one. Number two, company is entering into contract with him in that he is making a profit. One way. Way number two. Way number two. In the explanatory statement, this is one way of explaining. Way number two. Contract is being entered by the company with the brother of the director. Generally, if company enters into contract with others, unrelated parties, okay, selling price, purchase price will be 100. Since he is a brother of director, he will provide some extra benefits. For that extra benefits, we are paying extra 10 rupees to him. This is the cost element. This is a profit element. Clearly, I can explain. Okay, whichever of the following is correct when you read the word nature. Nature means what I need to disclose. Just to tell that he is my brother and lever, or I need to give a full explanation of facts. That means nature of concern means how the director is interested in the contract. Not directly, but through his brother he is interested. Just telling this is one way of literal construction, or make a broader way of explanation for that. That means sometimes occasions may arise when choice has to be made between two interpretation. One is narrow one, another one is a wider and bolder. In such case, if the narrower interpretation would fail to achieve the manifested purpose of the legislation, one should adopt the wider one. Just if you tell he is the brother of director, with him company is entering into contract, shareholders also will get confused whether to approve this or not. If you explain everything in detail, why that extra 10 rupees is given, full disclosures if you make, they can make more decision making. That's why when the law uses the word, the nature of concern or interest, the nature should be interpreted as any nature. Understood as any nature of concern or interest. That means full and frank disclosure without any suppression of the fact where son, daughter, brother, or father, mother or brother, sister is concerned in any matter. That's the meaning of this example. Okay? Write down. Write down. Example, sorry, below point number 5 or 6, write down. In some occasions, literal construction may give rise to two interpretations. One is a narrower one, another one is a wider one. One is a narrower one, another one is a wider one. Okay? So tell me, as per the intention of law, you should give narrow meaning or you should give a wide meaning? Wide meaning, better disclosures you need to give to the members. One is narrow one and another one is wider one. In such a case, wider literal interpretation should be adopted. Wider literal interpretation should be adopted rather than narrower one. Example. The words, sir, I will tell fast. If you want, you pause the video and write. Okay. For example, the words nature of concern or interest in section 102. The words nature of concern or interest in section 102. The nature of concern or interest in section 102 should be interpreted as any nature of concern or interest. Should be interpreted as any nature of concern or interest. Any nature of concern or interest. Any nature of concern or interest. Full stop, continue. What is required is, what is required is full and frank disclosure. What is required is full and frank disclosure. Full and frank disclosure without any suppression of facts. Without any suppression of facts. Without any suppression of facts. Therefore, full stop, continue. Therefore, a narrow interpretation may defeat the purpose of the law. May defeat the purpose of the law. Then what is the purpose of asking you the nature? Nature means any nature, small or big, you need to disclose. Okay. That's all. This is a main concept. Okay. Again, same here. Sir, see here. Natural and grammatical meaning. Statute should be understood in the natural, ordinary sense. It should be construed according to plain, literal, grammatical. Inconsistency is there. Okay. Then you should be going for a modification. Like that he is telling. This is not important. Whatever the 6 points you have written, that will be most important for you. When you find time, you read an example and leave. Examples, they don't ask in exam. You need to first write down the main concepts. These examples within the topic, you write down. 6 points or 7 points you have got. 5 marks you will get. Okay. Next. Keep the heading, rule of reasonable construction. Rule of reasonable construction. Rule of reasonable construction. Okay. First listen. Listen first. The main thing that everyone has to understand is, whenever you read the law, whenever you read a section, read in that a meaning, read in such a way that the words of the statute should lead to a sensible meaning. What is sensible? Sensible meaning is most practical meaning it should give. Means in what context they are using, in what concept they are using, with what intention they are using, same meaning should be given to the words used in the section. Sensible meaning has to be given. Okay. Sensible meaning has to be given. That means whenever law is read, read by giving the meaning to the words their ordinary meaning. Read in a sensible way. Read with their ordinary meaning. But if there are two interpretations for the words used, if there are two interpretations for the words used, if there is a capability of two constructions in such a case, which will further the objects, means what is the purpose of the section? Some purpose is there. Which interpretation will make the purpose of the section more successful? Two meanings are there. In the two meanings, which kind of interpretation will succeed the provision? That interpretation only you should give. Are you understanding the point or not? So similarly, when grammatical interpretation leads to absurdity, absurdity means nonsense, then courts shall interpret the statute so as to resolve the inconsistency and make the enactment consistent whole. The principle is based on the rule that words of the statute must be construed reasonably so as to give effect to the enactment rather than reduce it to a futility. Okay. So, read this point first. I will make you to summarize the points. Read the content first. This is very rarely tested question in exam, but still 5 points I will complete this. Read first. First thing is, words of statute must be construed, means understood, so as to lead to a sensible meaning. Point 1. Latin maxims you may not remember, so leave them. Main content you need to write. So, words and phrases of a statute should be given their ordinary meaning. Point 2. When the words of enactment are capable of two constructions, okay, capable of two construction, that there is a scope for interpretation or construction, then that interpretation which furthers the object, means which makes the objective of the purpose of the section more successful, can be preferred to that which is likely to defeat or impair the policy or object. That means there are two interpretations for that. First way of interpretation will kill the object. Don't go with that. Go with the second one. Okay, I will give an example. Institute did not give any kind of example. I will give one good example also. Okay. Similarly, when grammatical interpretation leads to manifest an absurdity, then court shall interpret the statute to resolve that inconsistency and make the act more consistent. Okay. So these are all the points. Next, again, like same song they are repeating again and again. When the grammatical interpretation leads to absurdity, court will depart from them and interpret the provision of statutes in a manner which will avoid the absurdity. This departure means going away from grammatical construction is possible or permissible only to the extent it avoids such absurdity and no further. This is also called as a golden rule of interpretation. Next, again same song. If the courts find that giving a plain meaning of the words will not be fair, okay, it becomes the duty of the court to depart from the dictionary meaning and adopt the construction which will advance the remedy and suppress the mischief, provided the court does not have to resort to conjecture or surmise. A reasonable construction will be adopted in accordance with the policy and object of the statute. All nonsense if you remove. I have to get 5 marks in exam. What are all the points I need to write? Let's concentrate on that. Okay, write down the notes. Simply what it wanted to tell, sir, in summary, if you want me to tell, only one point. If literal construction fails, go for reasonable construction. That's the meaning, over. If literal construction fail, go for reasonable construction. Means there are two meanings. Literally I can't interpret. Two different meanings are there. Not narrow and wider. Two different meanings are coming for the same word used. What interpretation I need to give for that? Which will survive the purpose of the provision. That meaning you have to give. I will give an example. I will give example. Okay. 2 examples I will give, not one. Institute does not give even a single example. I will give 2 examples for this. Before that, write down the notes. Point 1. Point 1. This rule is also called as golden rule of interpretation. This rule is also called as golden rule of interpretation. This rule is also called as golden rule of interpretation. Number 2. Number 2. Words of the statute. Words of the statute. Words of the statute must give a sensible meaning. Must give a sensible meaning. Must give a sensible meaning. Point number 3. Point number 3. The words and phrases of a statute, the words and phrases of a statute must be given their ordinary meaning. Must be given their ordinary meaning. Okay, full stop, continue. However, when the words of the statute, when the words of the statute are possible of 2 constructions, means 2 interpretations, 2 constructions or 2 interpretation, 2 constructions, comma, that interpretation which will further the object of the provision, must be adopted. Point number 3 or 4, whatever the case may be. That means when the grammatical interpretation leads to absurdity, underline that, leading to absurdity. You have to write that word in exam. When the grammatical interpretation leads to absurdity or inconsistency, absurdity also called inconsistency. Inconsistent with what? Inconsistent with the meaning of the provision. Lawmaker wanted to tell one thing. If I give this meaning, it is against to the provisions of what he wanted to convey. Okay? If the grammatical interpretation leads to absurdity or inconsistency, then the courts shall interpret the statute. Then the courts shall interpret the statute. Interpret the statute so as to resolve that inconsistency. So as to resolve that inconsistency and avoid that absurdity. Avoid that absurdity. Avoid that absurdity. Last point. To conclude. To conclude. To conclude. Comma. If courts find that plain meaning is not fair, plain meaning is not fair, plain meaning is not fair, then it can depart from the dictionary meaning. Underline this line. It can depart. Depart means go beyond. No literal construction. Go beyond literal. It can depart from the dictionary meaning and adopt such interpretation. And adopt such interpretation. From this again underline. Adopt such interpretation. From here underline. Okay. Adopt such interpretation which will advance a remedy, and suppress the mischief. Mischief means whatever nonsense is there. Suppress the mischief. Okay, that's all. These are all the various points you need to remember for the purpose of reasonable construction. Keep the heading. Rule of harmonious construction. Rule of harmonious construction. Rule of harmonious construction. Very popular in our classes. I repeated this so many times. Okay. Mainly when we are discussing about AGM, there are 3 time limits. What are the 3 time limits? AGM must be conducted in every calendar year. Gap between 2 AGMs should not be more than 15 months. At least 1 meeting must be conducted in every calendar year. And 1 AGM must be conducted within 6 months of the closure of financial year. How to interpret this? Earlier should be interpreted. Rule of harmonious construction we read. Okay. First I will explain you the concept. After that we will write the notes. Okay. See, by the way, I forgot. Reasonable construction example I didn't tell. Study material, no example is there. So you need not write example. I will tell the meaning. See here. In one of the act name is the High Courts Act. Which one? High Courts Act is there. In that High Court Act and Supreme Court Act, they have written this way. An advocate who completed his experience of 25 years, okay, is eligible to practice in Supreme Court. Means, simple words if I have to tell, plain dictionary meaning you give. If you complete, I mean, you mean here advocate. If an advocate completed 25 years of his normal practice, okay, then you are eligible to practice also in the Supreme Court of India. This is a sensible meaning. Okay. Now I got a doubt. Today I am working in a district court. In Hyderabad, in a district court I am working. Rangareddy court is there. Medak district court is there. Hyderabad court is there. Or you understand? Metropolitan court is there in Hyderabad city. In Metropolitan court I am working. First I worked in normal city civil court. Later I came to the sessions court. There I worked for around 8 to 10 years. Later I worked in the Hyderabad Sessions Court. Later I went into the Metropolitan Court in Hyderabad city. All this I worked in the last 25 years. I never worked in High Court. I never worked in High Court. Now the question, what you said, if I complete 25 years of practice, I can directly go to the Supreme Court to practice as an advocate. Now question arises, can I practice in High Court with 25 years of experience? When I use the word, you are eligible to become a advocate to practice in Supreme Court. Okay, there are two meanings for that. Only Supreme Court, also High Court. You didn't mention anything about High Court. How to interpret the provision now? Are you understanding or not? It is reasonable to interpret that. It is reasonable to interpret. Literal meaning, if you take, what is the meaning? Grammatically, if you take Supreme Court, means there is only one Supreme Court in India. In that Supreme Court, you can work. What about High Court? There is no meaning for that. But High Court is one level below the Supreme Court or not? Yes, one level below the Supreme Court. When you are eligible to work in the Supreme Court, it is obvious that you can work also in High Court with that experience. That's the interpretation you have to give. No, there is a word only Supreme Court. They didn't tell anything about High Court. Therefore, High Court not permitted. Supreme Court is permitted. Array, High Court is one level below Supreme Court only. Did you understand the point or not? That's the meaning. Are you understanding the point or not? For example, circle inspector can register a traffic violation case. Can register a traffic violation case. Traffic violation case. He can register. Circle inspector can exercise his powers in regard to traffic violation case. Okay, this is the question. Okay, traffic violation happen, then he can take an action against a person who is violating the traffic rules. Can circle inspector have a right to stop a person if there is a doubt? You should not tell after registering a case only he can do. When I have a right to take up a case, I also have a right to take in advance an action. So like that you need to understand the rule of reasonable construction. Are you understanding or not? Okay. Next. Rule of harmonious construction. So the next rule. Keep the heading. Rule of harmonious construction. Rule of harmonious construction. Rule of harmonious construction. Okay. First, let me explain the concept. Whenever I just know I said na, whenever I say harmonious construction, first thing is harmony means putting all at a same level. Okay, that means justification given for all the provisions in the same way. I will give you an example here. In a school, outside in the board, they have written do's and don'ts book was written. What students should do, what a student should not do. Page number 1 they said, students should be attending to the school on time. Over. 10-15 pages after another one is also given. Students should maintain proper uniform at all the times. Over. After another 30-40 pages when I read, there is another phrase saying that students should not stay in the school beyond half an hour after leaving the school. They said, like this 4-5 statements are made. A student got a doubt. In page 1 you said that, I should attend on time. Page 20-25 you said uniform should be maintained. Some page 70-80 page you said that I should leave within 30 minutes of completion of the school timing. Which one I should follow? 3 things you have written here. Which one I should follow? Like this they asked a question. What the school management should tell? At a muttal, you should harmoniously interpret. Give effect to all the 3. Come to school on time. Maintain a proper uniform. Leave the school not more than 30 minutes after leaving the school. That's all. When 3 different provisions are provided, give effect to all the 3. If really one thing is nonsense, why I will write first in that? When I write something in the do's and don'ts mean, you have to follow everything. Are you understanding the point or not? So therefore, like that in Act also, there are so many sections in the Act. One section will say something on the same concept. Here, what is the same concept in my example? Do's of a student. Do's of a student. One page, one do I said. Another page, another do. another pele, another do. All do's you have to merge and interpret. You should not tell that uniformly if I come, I can leave to the school even after 30 minutes. It does not mean that. Following one will kill another. No. Did you understand the point or not? So the main thing that you need to understand is, okay, the main thing that you need to understand is, whenever multiple provisions are there, which are discussing on a same subject matter, all the provisions should be given their meaning. However, sometimes it may not be possible to give meaning to all the provisions in a equal way. In such case, conflict arises. In such way, conflict arises. Opposite to the word harmony is the conflict. Harmony means peace, not P-I-E-C-E, P-E-A-C-E. Harmony means peace. Conflict is the opposite to the word harmony. Whenever multiple provisions are there, don't create a fight between the provisions. Peacefully apply all the provisions. Sometimes it may not be possible for harmoniously constructing all the provisions. In such case, specific rule should prevail over general rule. Okay, also called as specific section should prevail over general section. Understood the point clearly? All these let us write down in the form of a notes and complete it. Easy area. Yeah. Paragraphs is there na? Nonsense is there. Whatever important for the exam point of view, let us write that. Write down. Write down. Okay. Write down the point. In interpretation of statute, in interpretation of statutes, in interpretation of statutes, in interpretation of statutes, the words used, the words used, the words used should be understood in a sense, should be understood in a sense, understood in a sense which harmonizes to their best, which harmonizes to their best with the object of the statute, with the object of the statute. Next point, point number 2. The opposite to the word harmony is conflict. The opposite to the word harmony is conflict. Okay, full stop. Point number 3. That means this rule is applied. That means this rule is applied when there is a conflict between two provisions of a statute. Conflict between two provisions of a statute. Okay, conflict between two provisions of a statute. That's the main point you need to write here. This paragraph I made you to write now in a simple language. Okay, next. This content I am going to make you to write in a summary. Okay, write down. If there is a conflict between two provisions, if there is a conflict between two provisions, if there is a conflict between two provisions, if there is a conflict between two provisions and it is possible to avoid the conflict, and it is possible to avoid the conflict, possible to avoid the conflict, on a proper interpretation. That means if you give a proper interpretation, conflict will be avoided. With a proper interpretation, then it is the duty of the court. Then it is the duty of the court. It is the duty of the court to construe them in a harmony. To construe them in a harmony. To construe them in a harmony with another. With another. With another. Okay. However, next point. However, if it is not possible to give, however, if it is not possible to give effect to the provisions harmoniously, if it is not possible to give effect to the provisions harmoniously, then underline this statement, specific rule should prevail over general rule. Specific rule shall prevail over general rule. Prevail over general. Next point. Listen, conflict should be a real conflict. You should not feel a conflict. Really problem should come. Okay. Then only this will be interpreted. You should not create a conflict and try to resolve. That's what the next one. Okay. Next point. It is to be noted that this is very important line. Write down. It is to be noted that this rule can be adapted only if, very, very important lining. Exam, you need to write this. It is important to note that this rule can be adapted only if there is a real conflict. There is a real conflict. There is a real conflict, but not apparent conflict. Apparent conflict means it seems to be like a conflict. Like should not be there. Really it should be there. Not a apparent conflict between the provisions. It should be a real conflict but not an apparent conflict between the provisions. Okay? Okay, full stop. Last point. Keep the heading. Exceptions to harmonious construction. Exceptions to harmonious construction. Okay? See here. I will explain first, later you read. When harmonious construction cannot be used, if the lawmaker uses the word subject to the provisions, notwithstanding the provisions, without prejudice to the provisions, means what? I will give you 3 examples. Subject to the, for example, I am reading a section. They are using the word subject to the provisions of section 100. What does it mean? This section is subject to provisions of that section. Okay, in this section something is said. Okay, in another section some other thing is said. In another section some other thing is said. Subject to that provision, this section has to be read. Means what? You have to read this section, means read that section first. Without contradicting to that section, read this. Means what? Lawmaker is only telling clearly that you should read both the sections together. In this case, why you are harmoniously interpreting? Lawmaker is telling that harmoniously interpret. Then no need of you making construction, because already section uses the word subjected to. Second, without prejudice to means what? When you read this section, for example, in a section, without prejudice to provisions of section 100, they have written like that. What does it mean? When you read this section, okay, first read 101, other section, first read 100. Read this section. If this section is going against 200, don't interpret that meaning. Means what? This section should not damage the intent of other section. Damage the intent of other section. I will give an example. 185, 186. 186 uses the word without prejudice to provisions of this act. What is 185? Loans to directors. Loans to directors. This is loan to any person. Loan to any person. Okay. Means what? See here. Loan to director prohibited. You cannot give. You cannot give. As per which section? 185. Not permitted. Sir, can I take permission? I said illegal, prohibited. Prohibited, what permissions you will take? So not at all permitted. 186 says that loan to any person can be done by passing a special resolution. By passing a special resolution. Now tell me. Problem comes like this. 185 says loans to director is prohibited. 186 says loan to any person is allowed, but only with a special resolution. In this any person, director also will come. That means as per 186 you can give loan. As per 185 to the same director you can't give the loan. Which one I need to apply? Two provisions there is a conflict. No conflict because in the section A he said without prejudice to the provisions of this act. Means if in any other section already something is said, okay, except that every other thing you should interpret here. Means what? In this any person, director should not be included because if you include director here, then it will kill section 185. Without killing 185, you should read this. That's the meaning of without prejudice. Such that harmony is established. That means whenever the word without prejudice, subject to provisions, like that if they use, I am only telling that, okay, I am only telling that this section is to be read along with another section, or this section should not defeat another section. I am only telling that there is a harmonious construction. So you need not again make any harmonious construction on that. Next, subject to. The impact of the word subject to when used in a provision is that when same subject matter is covered by that provision and by another provision or enactment, subject to which it operates, and there is a conflict between them, then latter will prevail over the formal. Means what? Subject to provisions of 100 means which one will prevail? 100 section is more important than this. Subject to that, you have to read this. Okay? I am not going to give any notes on this. Read this content and you have to write in exam. Next. Notwithstanding, class, how many times I said about this? Yeah. Listen. Notwithstanding means ignoring. Okay. If I use the word subject to provisions, for example, there is a section called as X. In this X section, I wrote subject to provisions of section 50. Example means which is more important? Section X is more important. 50 is more important. 50 prevails over this. Okay. Notwithstanding means which section uses notwithstanding will prevail. Okay. Notwithstanding is called as a non-obstante clause. Non-obstante clause. It is opposite to subject to. Okay. So that's why clause having non-withstanding clause has effect of making the provision prevail over another. Means section using notwithstanding will have more energy, more power. Okay. Now listen. There are 4 kinds of notwithstanding. Notwithstanding anything contained in another section means it will override only that other section. That's why such other section. Example he has given, later you can read. Notwithstanding anything contained in the statute, it will override that act. That act. Next, notwithstanding anything contained in sections or subsections in another statute, it will not override that act or that section. Other enactment it will override. Notwithstanding anything contained in any other law for the time being in force, it will override all laws. Without prejudice also I have given. Okay. So with this we completed the rule of what is the rule? Harmonious construction we completed. Okay. Hedon's rule, keep it on hold. See here. I will go directly to ejusdem generis. Ejusdem generis. So many times I also discussed about ejusdem generis. By the way, you are writing the notes on harmonious. Exceptions. Write down. Write down exceptions. When law uses the words or law uses the phrase when the law uses the phrase, keep in quotations, subject to, subject to, comma, without prejudice to, keep in quotations, without prejudice to, or notwithstanding, notwithstanding, then already law itself has, already law itself has, law itself has integrated two sections, integrated two sections, integrated two sections. No further harmony is required. No further harmony is required. No further harmony is required. Brackets will write down, refer ISM. For what? For subject to all these things are there, na? Just read the ISM. Okay. Ejus dem generis. See here. Sir, this also so many times I told you in the class. What is the meaning of ejus dem generis? Listen. Ejus dem generis says like this. What it says is, there is a particular statement. Okay. There is a enumeration of specific words. Specific words are followed by a general word. Okay. First, there are specific words. Specific words are followed by general words. Okay. Specific words belong to a same category or a species. Then the general word should be given a meaning. Okay, general word should be given a meaning which is similar to that of the specific words. Example, when I use the words, I have a huge fear towards lion, tiger, leopard, etc. Etc. should be given which meaning? Hen, ant, mosquito, all those. Try to understand clearly. I use the words in a species, genus. Means what? Lion, tiger, leopard, all these are wild animals. These are not domestic pet animals. These are all wild animals. Okay. When I use the word etc. in the context of that wild animal, that etc. should take the meaning from previous specific words. It should not take whatever animal you want. It should take the meaning from the previous specific words. Only certain things which are coming into that. You can include a puma. You can include a hyena. You can include a fox. Like that you can include. You can't include whatever you want into it. Are you understanding or not? So therefore, you should include only those which comes under that species. Okay. So likewise, law also same. There should be enumeration of specific words. Point 1. You need not write. Already they have given in points. Okay. That enumeration of words should form part of a class or category. My category is wild animals. The class or category is not exhausted by enumeration. Listen here. I said this way. He is doing experiments on. He is doing experiments on Mercury, Venus, Earth, etc. I said. What does it mean? Etc. should take the meaning of what? Other planets within the solar system. Because those three belong to our solar system. Okay? Number 1. I said, he is doing experiments on Mercury, Venus, Earth, Mars, Jupiter, are you understanding? Saturn, Neptune, Uranus, Neptune, etc. What is that etc.? I explained all the things. That means my specific words has exhausted the entire enumeration. Therefore, the class or category is not exhausted. There should be some chance to put the meaning of the word etc. there. Okay. General term should follow the enumeration, specific words. Okay. There is no different legal intention. So mainly, there should be specific words. Specific words are followed by general words. Specific words should belong to a same class or category. The class or category should not be exhausted by specific enumeration. There should be no different legal intention. In that case, the general word should be given. In this case, the general word should be given the meaning of the previous specific words. Where specific word pertaining to the class or category are followed by general words. General words shall be construed as limited to the things of the same kind of those specified. Simply, the general word should be given a meaning of the previous specific word. Clear? exceptions are there. If the preceding term is general as well as that which follows this rule cannot be applied. Okay, meaning what? General word A, but it is not used in the sequence. Example I will tell you. See here, I said this train goes from, say example, this train goes from Kanchipuram via Tirupati via Nasik, like that I said. All these places are pilgrimages. All these places are a normal visiting spots. These are pilgrimages. Etc. If I use, you can add other kinds of pilgrimages in the same route. Okay. Second, this train connects Munnar, Ooty, Coorg, etc. All these are holiday spots. Etc. include holiday spot. Now listen. This train connects Kanchipuram, Tirupati, okay, Tirupati, next Coorg, Goa, etc. Goa and Coorg is a holiday visiting spot. Tirumala and this Kanchipuram is a pilgrimage place. Then how to understand the meaning of that etc.? That's the meaning. Next, particular words exhaust the whole genus. I told example, same. Okay. Next, specific words are diverse in character. Now the problem is not with the general. Specific words, they used irrelevant 3-4 words and used etc. Then also it will not give the same meaning. Are you understanding the point or not? Or law intentionally says that etc. should not be given ejusdem generis. It should be given this meaning. That means there is a word called as other. In a particular section, law uses the word others. Certain things they said. Directors, manager, KMP and others. Who is others? Any other officer should be included. Correct? But law clearly they said in the section. Explanation. The word others mean. They only said what is the meaning. In that case, law has a different intention for the word others. You should not use this word. Use this rule. Where? Express intention of legislature that general terms should not be read as ejusdem generis. In that case, you should not use the ejusdem generis. Okay. 4 exceptions are also important for the exam. With this, we completed all the important rules of interpretation. Okay. Next video, secondary rules of interpretation also will come immediately after this. In that, secondary rules of interpretation with exceptional I will do. That's all. Listen to these videos and go to exam. Success will be yours. 10 marks pakka in the particular exam. Okay. Thank you.